To tilling a windmill. This is Dwight Lilly. This is the 11th edition of Right Talk. It's February the 6th, 2015. Today I thought I would go over the upcoming Senate Bill 65, that there's going to be a reading of it, a discussion of it, this coming next Wednesday, I guess it would be, in Carson City, Nevada, as the legislature meets. And several of us will be traveling down to the legislative building in Las Vegas so that we can give testimony. But what I wanted to do and get this up today is to go over what some objections are to Senate Bill 65 and comparing it to historical basis for water regulation and use here in Nevada. This is about a 4-page document, so I'm going to read this into the video here so that when you're watching, you'll be able to get the gist of what we're going to be arguing down there. If I stammer a little bit, forgive me, but oh, by the way, how do you like my orange shirt? I thought I'd wear that today. Kind of a bright color, because this is an alarming subject that we're talking about, so bright goes with alarming. Okay, this is a review of Senate Bill 65 to amend NRS, that's the Nevada Revised Statutes 533. The Nevada statutes from statehood in 1864 to 1902 contain only 3 acts related to underground water, whereas 20 statutes relating to surface water were enacted during the same time period. These 3 statutes were enacted in 1879, 1887, and 1901, and provided bounties for the development of artesian water. The early legislature seemed to construe artesian water as water under free flow. In other words, a well would have to be a flowing well to be clarified as an artesian well. And as you know, the wells that we have here in southern Nevada, we don't have really free-flowing wells at our property. We have wells that you dig down and you access the percolated water below your property, and you use a pump to pump the water up into your pressure tank, and then from the pressure tank to your home. So it's not free-flowing, it's just there, stagnant, laying there in the ground. Early Nevada Supreme Court decisions held that percolating water belonged to the landowner, which would be you if you own a house or happen to be in possession of a piece of property with a private well here in Nevada. It was held in an early case that water flowing underground in an undefined or unknown course belonged to the owner of the land, and that such owner was not responsible for injury caused to others by reason of his diversion of the water. For example, where it was the source of a spring on another's land, and that was in a Supreme Court case, Moster versus Caldwell, Nevada 363, and that was in the year 1872. Subsequently, in 1881, the rule of absolute ownership of percolating water was affirmed in Strait versus Brown, which is 16 Nevada 31740 AM, REP 497. The maxim to whomever the soil belongs, he owns also the sky to the depths, seems to pertain to what, this water belonging to our land. If you own the land, you basically have what's below you and above you. And that's an old maxim that goes back, I guess, to the beginning of when people determined who owned land and who didn't. The corpus of percolating water was held to be the subject of private ownership and real property as a part of the soil, whereas the corpus of running water is not part of the soil nor property in any sense of the word. No later cases have been found in which the rights of owners of underlying lands to percolating waters have been specifically stated. The state of Nevada first took cognizance of underground water as belonging to the public and subject to appropriation when it enacted a new water law in 1913. Sections 1 and 2 of Chapter 140 Statutes of 1913 read as follows. Section 1. The water of all sources of water supply within the boundaries of the state, whether above or beneath the surface of the ground, belongs to the public. Section 2. Subject to existing rights, all such water may be appropriated for beneficial use as provided in this Act and not otherwise. Going on here. The Nevada State Supreme Court decision Ormsby County versus Guernsey, 37 Nevada 314-315 of 1914, held sections 18 to 51, inclusive of the water law of 1913, are unconstitutional and void in that they attempt to invest the state engineer with powers to affect or destroy the property rights of water appropriators or users in violation of the due process law provisions of the federal and state constitution. And because they attempt to invest the state engineer with judicial powers reposed in the courts in violation of Article 3, Section 1 and Article 6, Section 1 and 6 of the state constitution. The first legislative act relating to the administration of underground water was contained in Chapter 210, Statutes of 1915, and remained in force until repealed by the more detailed groundwater law of 1939, Chapter 178, Statutes of 1939, Sections 1 of the 1915 Act read, quote, all underground waters, save and except percolating water, the course and boundaries of which are incapable of determination, in other words, they're not running, they're just down there in your ground for your use, are hereby declared to be subject to appropriation and the laws of the state relating to appropriation and use of the water. Emphasis added. The balance of the act related to the drilling and control of artesian water. In 1939, Groundwater Act eliminated the reference to percolating water and made all groundwater capable of being developed, subject to appropriation laws of the state. As stated above, there is no Nevada Supreme Court decisions eliminating the 1878 and 1881 reference to percolating groundwater. Percolating water is part of the soil. Water percolating through the soil is not and cannot be distinguished for the soil itself, and of such water the appropriator of the soil has a free and absolute use. In other words, the well owner has free and absolute use of that water underneath his property, so that he does not directly invade that of his neighbor or consequently injure his perceptible and clearly defined rights. If Senate Bill 65 is adopted, Section 3, quote, source of surface water or groundwater includes without limitation a stream or stream system, cannot be justified by the state engineer. No definition has been provided for an underground stream or stream system. He has not mapped or determined the amount of water in the channel of the stream or stream system under the ground. The state engineer has no knowledge of the age of the water. Water can be carbon dated. Isotopes of oxygen in water molecules are used to determine the source of groundwater and the direction of groundwater movement. And tritium, frequently used as a tracer in groundwater studies. Tritium, which is hydrogen-3, is a radioactive isotope of hydrogen. It has both natural and human-made sources. Large quantities of tritium was produced as a result of atmospheric testing of nuclear bombs beginning in the early 1950s here in Nevada. This so-called bomb tritium is present in the groundwater that entered aquifers after the early 1950s. Thus, the presence of large concentrations of tritium in underground indicates the presence of modern water. That is, water that entered the aquifer after the early 1950s, which can also be used to determine the direction and rate of groundwater movement. Section 5 to 8 of this new law, The change requested in this new Senate Bill 35 is not necessary. This section was amended in 1913. The state engineer should allow the present NRS 533.135 fees of state engineer disposition. 1. At the time of submission of proofs of appropriation, where the necessary maps are prepared by the state engineer, the fee collected from any claimants must be the actual cost of the survey and the preparation of the maps. 2. The state engineer shall collect a fee of $60 for proof of water used for watering livestock or wildlife purposes. The state engineer shall collect a fee of $120 for any other character of claim to water. 3. All fees collected as provided in this section must be accounted for in detail and deposited with the state treasurer into the water distribution revolving account created pursuant to NRS 532.210. And that's pretty much what that section says. On Senate Bill Section 9, that is amending the NRS 533.065 standards of measurement. 1. A cubic foot of water per second of time shall be the legal standard for the measurement of water in the state. The unit of, number 2, the unit of volume shall be an acre foot, defined as 43,560 feet. If you have a private well, you just take 2 of those, because you'd have 2 acre feet to use on your property. 2 times 43,560 cubic feet. At your disposal. 3. Where necessary to transpose miner's inches to cubic feet per second, 1 cubic foot per second shall be considered equal to 40 miner's inches. But the term miner's inch shall not be used henceforth in any permit or adjudicated right issuing from the office of the state engineer without first naming the amount in cubic feet per second or in acre feet. Changing the historical definition of water like spring, creek, stream system, percolating water, and common law property of beneficial use will allow the state engineer to become the water czar of Nevada. I'd prefer to call him the king of, his name's Jason King, but the king of water is what he's trying to become. Now, as I've said in previous programs, there's no really need for these changes. What Jason King is trying to do, trying to get the legislature to do, is to give him new definitions of what has already been set in law, in court cases, going back all the way to the 1860s when the state was formed. And for those of us that came after the laws had been enacted, up until this point, into this attempt to revise them here in Senate Bill 65, we bought our property. We had well companies dig down into our percolating water, which is the soil underneath our property, so for our use. And we have the legal right to 2 acre feet of that water. To change this would be changing the entire terms and conditions that we bought our property from to begin with. It would be, in a sense, it'd be stealing an asset from us, because we own that water underneath the property, because as I said earlier, from under the ground all the way to the sky is what's defined as what our property rights are. I'm going to urge the state legislature to abandon this attempt to just create a mess of all the rights that people have here that have wells, over 11,300 of us, and we'll just get back to the very core issue here, which I brought up before and I'll bring up again here now, is that the state over appropriated water rights. Now you and I, if you have a private well, you don't have water rights as a sense that they are something that's traded. you have the right, because you own the property, to the water below you. Each plot of land that a home's put on has the use of 2 acre-feet of water per year. That can't be taken away from us unless the legislature tries to change the law, where Jason King could come in as a state water king, water czar to you, and try to change and manipulate what the terms are that we have had since the 1860s as private property owners here in Nevada. It's not only not fair, it's just totally irresponsible to put so many people here in the valley that are retired, that are in fixed income, in a position where they basically have lost valuable asset, the very water underneath their property. For them to come in and try to say you no longer have 2 acre-feet, the water czar now says that he's determined that you only have 1/10 of 1 acre-feet to use, and to bring down the the law on us for using what has been rightfully ours since we purchased this property. This is just absurd, is what they're trying to do here. So this is what I wanted to read. Next week, like I said, today's the 6th of February, so I guess it would be Saturday's the 7th, Sunday's the 8th, 19th. The 11th of February, we're going to be down in Las Vegas. The hearing starts at 9 o'clock in the morning, and we'll be at each one of these hearings. Those that are on the, that happen to belong to the Private Well Owners Association will be with me. The person that put this document together, his name is John Bosta, and he'll be with me, and the president of the association, or excuse me, the co-op, Frank, will be with us, and we're going to explain to the legislature why we believe this is a bad Senate bill and that it should be rejected outright. And I thank you, and that's all I have today.